Hey, 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 what's up, y'all? It's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hey, y'all, what's up, Alice? Tony just published an email that was an agreement to dismiss the sanctions, the case, and stop. I have not done any of my work outside of this, so there have on the 11th. There were a total of how many did I count? I'm losing count. I think it was like 7 to 11 filings. So I have been pulling them and I have been reading them and I have pretty much broken it down. Um so I have to do this in chunks. So yeah, I've already pulled the docs. I have already gone over them. So instead of me doing another video, I was like, girl, just go live. So at 6 o'clock, I have another video that's coming out, but it's going over the declaration, the second declaration of Jane Doe, as well as the objections that Shepard Mullen, and that is the law firm that's representing Tony Busby in the Jay-Z and Busby case. They ended up filing objections to Charlotte Henderson's declaration. So I did a video on that, and that's coming out at 6 o'clock. But if y'all been tuning in all day, I've been having to do this in chunks. So that is what we're actually going to speak about today is the other declarations that were submitted on the 11th, along with Jane Doe's declaration that I just read. But we're doing the attorneys, we're doing, and we're going to read the opposition that they submitted. Before I get going, yeah, it is a lot. That's why I have to do this in chunks. When I said I have not done a lick of work, I haven't. But I promise tomorrow I'm not doing no YouTube and I'm actually going to work. Hi, Brianna. How you doing? What's up, Twitcher with Heavy? What up, girl? Jane just released another explanation saying they doctored the tape and harassed her. Yeah. So I did all that. Yeah. So my video, that's coming out at 6 o'clock. It goes over that. I've been working on this all day. Like I said, it's several filings that were filed on the 11th. So I have to go through all of those and ensure that what I'm reading, I have the declarations to kind of match that. Let me see. I have Jane Doe's declaration, Tony Busby's, Katzowitz, Fortney. Hold up, I'm trying to get my declarations in order. I'm missing somebody. Vasquez. All right, so Vasquez. Who am I missing? I'm missing somebody's declaration, but that's okay. It is a lot to unpack. I'm not gonna too much go over a lot of stuff only because I have a video that's coming out just specific for Jane Doe's declaration. So that's one thing. What's up, sexy Nessa? There we go. Yes. So without further ado, let's get into this because I don't want to spend all day trying to go over it. Let's see. All right. So what we're going to read is the opposition. So y'all know it's a gazillion cases that are going on right now. But this particular case that we're speaking on is the California case where Jay-Z under the pseudonym John Doe, filed this particular lawsuit on November 18th, the day before his response was due to the Jane Doe and John Doe demand letters. This is the lawsuit that Jay-Z filed. Quinn Emanuel is representing Jay-Z in this case. For Busby and his law firm, he has Shepard Mullen, who is the firm that represented Johnny Depp in his case. So I want everybody to understand this. So Busby's not working on his own case. He has Shepard, Mullen, Richard, and Hampton who is working. Camila Vasquez was Johnny Depp's attorney, probably still is, but this firm is good. Okay. So we have the opposition because how we got here is Jay-Z filed the lawsuit first for extortion, then he added defamation. Then Busby submitted a motion to strike parts of Jay-Z's amended complaint based off of the things that Jay-Z said that Tony Busby said about him. Then they had a hearing on the 25th of what is that, February. And I went over that in the video. I don't want to sound repetitive or anything of that nature. And in that, the judge told Jay-Z's Quinn Emanuel specifically, one, he is not going to continue with the extortion case because they had no proof that there was any ever, extortion in those demand letters. They demand letters did not even give a number as to, it didn't say, hey, give me $6 million or we're going to threaten to sue. These are typical demand letters. Demand letters is like telling somebody, if you don't do this or if you don't agree to this, then we are going to pursue litigation. That is standard. That is what we send out before we even start litigation. Okay. So the judge was like, that's off the table. Then he goes to the defamation part and he says, if you can provide me with evidence, not hearsay, but tangible evidence, then he will consider. I did a video on that and I broke that down and I explained. The judge specifically said he does not want to hear hearsay. The video that's coming out at 6 o'clock, you're going to understand why. A lot of what's said in the declaration that's submitted by the private investigator is hearsay. Yes, I am always working. I need to be working on my business, on the actual legal stuff instead of doing YouTube. But I was like, I have to do this and I have to get this out because I'm behind. But I've been reading this all day. I feel Tony purposely not aggressive because he will slide, and he will, as I stated last night, in those two cases in Houston. No, not the two cases in Houston. The two cases in Louisiana. Those are going to be dismissed like the case was in New York with Claudia Brady because of a contract that they signed. So Busby works very strategically. He knows what he's doing. What people, the thing is, it's publicized. People don't understand the legal process. So everything they push the narrative on a lot of stuff. They take everything out of context, not understanding what the process is. And that's what makes things so bigger than what they actually seem. Tony Busby knows what he's doing. There's procedures that you have to go with this, okay? So going into the opposition, how can I say this? Okay, so back to the defamation claim. So the judge says, you present me with new evidence, then we can consider. So what does Jay-Z and his team do? They start, I don't even know what they start doing, to be honest. The judge told them, he even told the attorney, I'll give you 10 minutes to call whoever your investigators to give me a name or whatever evidence that you have found. But he could not do it because he was banking on those investigators to get Jane Doe to sign that affidavit. That is what Quinn Emanuel was banking on, but she didn't do it. I ain't gonna say too much because y'all gotta watch the video. But with that being said, so now Jay-Z is trying to entering all this stuff. so he could supplement discovery and all this other stuff to enter into the new evidence. And guess what Shepard and Mullen is saying? No, all this stuff that you're trying to submit is inadmissible. It's a bunch of hearsay. The judge straight up told you that we're not going off of hearsay. But this is where we are at today. So this is Shepard, Mullins. This is the attorneys for Busby and his firm. This is their opposition to Jay-Z's ex parte application to supplement the record or obtain discovery in connection with defendant's special motion to strike. It is a lot. It is a lot. So y'all put y'all bootstraps on. If y'all on your way home, hey, we gotta listen. So this kind of gives you an idea of what we're gonna cover. I'm gonna try to just, breeze through this. But there's some things that I really want y'all to pay attention to. One, the timeline establishes that the theory advanced by Carter's new evidence is incontrovertibly false. Carter's new evidence from investigators is also inadmissible. Carter's other new attacks on Jane Doe are irrelevant. And the new evidence fails to salvage Carter's frivolous claims. Like, he is so big that has been defamed by Tony Busby, but yet he has no evidence that this is the case. Carter's request for discovery is improper and should be denied. So let's tap on into this. Let's tap on into this. So y'all, if y'all driving home or y'all getting ready for work, just tap in. Just tap in. All right. Carter and his attorneys should withdraw this outrageous and misleading application. The new evidence Carter has pro-offered to the court, even if accepted, would not justify the denial of the motion. Carter's claims all fail as a matter of law, and none of the new evidence he pro-offers comes close to salvaging his baseless First Amendment complaint, that complaint for defamation. Moreover, Carter's new evidence is inadmissible, and his reliance on Sweetwater and the hearsay exception for declarations against interest is misguided. Sweetwater does not apply to unsworn statements, and his new evidence was acquired under highly suspect circumstances from an intimidated witness who denies even making the statements. Such evidence lacks any indicia of reliability and is not within any hearsay exception. Now, mind y'all, this is not Tony Busby's pleading. Shepard Mullen is the one who drafted this complaint and submitted it on Busby's behalf. So they know what they're talking about. So let's get that clear. This is not Busby's document. This is Shepard Mullen. To be a matter of fact, let me see what attorney submitted this. Hold on. So I don't want nobody being like, tiny bit. Casey Suda is the attorney that is working on this case. So back to this. And let me see what I was saying. Okay, such evidence, I already said that. In any case, the new evidence advances a factual narrative that is demonstrably and indisputably false and lacks probative value. If Carter and his attorneys intend to advance the narrative stated in their new evidence, they do so with full notice that they are advocating a factual impossibility. The court need not and should not accept evidence that lacks evidentiary value or draw conclusions that no reasonable fact finder could draw. The incontestable facts establish that Carter's evidence is false, if not fabricated, and his arguments are frivolous. The rebuttal evidence shows that Jane Doe was referred to Busby parties to prosecute claims against Carter and others in early October of 2024. After extensive diligent efforts, the Busby parties filed a complaint on behalf in October of 2024. which included specific allegations against Carter, who was identified therein as Celebrity A. Jane Doe authorized the sending of the demand letter to Carter in November. Jane Doe executed two sworn affidavits in support of her allegation against Carter, one on November 18th, 2024, the next one on December 8th, 2024. And also on December 8th, 2024, Jane Doe authorized the filing of the first amended complaint that identified Carter by name as defendant. So they already knew back in October that there was allegations against Jay-Z, but they just can't include him into a lawsuit. Thus the reason a demand letter was sent out asking for a confidential meeting to sit down and talk about the allegations. Not once did the demand letter ever state a monetary value. They wanted to sit down and get more information about the allegations that Jane Doe brought forth back in October. But since Jay-Z refused to have that sit down meeting with them, the demand letter already told you what's going to happen. We're going to include you in a lawsuit. The ball was in Jay-Z court. He failed to do it. Carter's new evidence nonsensically postulates that Mr. Busby convinced Jane Doe for the first time to sue Carter on December 11th, 2024, after all of the foregoing events had already occurred. This demonstrably false theory, supported only by inadmissible hearsay obtained under highly improper circumstances, need not and should not be considered. In fact, when Jane Doe was ultimately frightened by Carter into abandoning her claim, Carter's counsel at Quinn Emanuel, John Quinn, and Alex Spiro on one hand, and the Busby parties and the Jane Doe New York counsel, Mark Kasowitz, on the other hand, reached an agreement for a global walkaway, which included Carter in his attorney's agreement not to harass or interact with Jane Doe. Now, when Trump's attorney came into play, I knew it was about to go down because they don't play. So they all came to an agreement to drop the case. Everybody go their separate ways. And y'all agreed not to mess with this girl, not to harass her, not to interact with her, not to track her down. All of that was in an agreement. But yet, y'all did this. Oh, it's about to get juicy. What's done in the dark will come to light. And I showed y'all on the wall how Quinn Emanuel operates. The fact he hasn't submitted the audio, and that's another thing. That's why I didn't even report it. I refuse to even play that on my channel for the simple fact, if you rather submit an audio recording to ABC versus to US Legal to transcribe and file a certification through the court to authenticate the recording, I'm not listening to it, because y'all could have done whatever to that. Y'all could have altered it. The way that AI works these days, I would not be surprised. And if Jane Doe really came out and say Jay-Z didn't do this, don't y'all think that she would have submitted an an affidavit or a declaration to support Jay-Z? No. She submitted her declaration to support Busby. And Busby is not the one even asking for it. It's Shepard Mullen, who is representing the Busby law firm. If y'all don't know who they is, y'all better go check them out. So can't nobody say, well, Busby made her submit a declaration. No. Shepard Mullen is the firm that is representing Tony Busby and the Busby law firm. They reached out probably to Jane Doe and say, hey, would you like to submit a declaration? And this is how you do it. I've never in my life have drafted an affidavit or a declaration and called the client and say, "Hey, I need you to sign this." That's not how that works. You get them on the phone and you type, and once you finish typing, you send it over for them to review and either get notarized or they sign themselves. That is how a declaration or an affidavit work. If it's an affidavit, then I'll be like, okay, you need to print that off and you need to go find a notary, and that notary needs to give a verbal ceremony. That's what I do on affidavits. But since I'm drafting it, I can't be a paralegal and a notary at the same time. I have to pick one or the other. And a notary will ask you, is the contents in this document true and accurate? If it's a declaration, then you're saying, "Oh my mama, everything in this declaration is truthful." That's it. What's up, CC? And he could, yes, hibiscus, he sure could have. He could have walked away, but let me tell you something. Quinn Emanuel, before, like, if y'all have to dig into the files, just type in Jay-Z and Quinn Emanuel and past cases from the perfume case that I seen. Private investigators were stalking people, getting declarations from people. In the freaking Elon Black versus an ex-model who he sexually assaulted, Quinn Emanuel, specifically Alex Spiro, had people going to this ex-model's apartment complex, knocking on her door. This is a history with Quinn Emanuel. They use investigators to intimidate people, to harass people, to get their way. That's why people use them. Everybody be like, "Oh yeah, Alex Spiro be doing his thing. He know New York and da 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 da." Y'all have to realize the way that this Quinn Emanuel rolls. It's not even just about specifically Jay-Z case. These are, look at any other case. Just type in Alex Spiro cases and you would get a good internet search of how he be rolling. I agree. Tony Busby is very strategic. He would not go back and forth in the eyes of public opinion. I feel they are trying to bait him. TB isn't falling. He's not. He's definitely not. Have you covered the new evidence put out by Busby showing it? Yeah, this is where we are right now. This is what we are on right now. I have been working on this all day. I started with, hell, I didn't forgot what the world I started with. I know I started this morning. So it's a chain of events, but this one was a little bit too long and I was not about to do a video and then turn around and premiere it. No, I was like, let me just go live with this one. But after this at 6 p.m., I do have the second Jane Doe declaration along with the objections submitted by Shepard Mullen in regards to Charlotte Henderson, the private investigators declaration. But this right here, this is what we're going over right now. So right now, this is in regards to the opposition of them uh opposing Jay-Z offering new evidence in the form of these hearsay declarations. Yeah, they are aggressive. They are crooked. And even Alex Spiro, he sat up there, even though he tried to cover himself up, but he knows that they use investigators. Okay. In fact, when Jane Doe was ultimately frightened by Carter into abandoning her claim, Carter's counsel at Quinn Emanuel, John Quinn and Alex Spiro on one hand, and the Busby parties and Jane Doe New York counsel Mark Kasowitz, on the other hand, reached an agreement for a global walkaway, which included Carter and his attorney agreement not to harass or interact with Jane Doe. Jane Doe dismissed her claims in New York on February 14, 2025, in reliance on that agreement. It now turns out that within a week of the dismissal, investigators ambushed Jane Doe at her home on February 21st, 2025. Meanwhile, Carter's attorneys in California, on the other side of the United States of America, cited the dismissal as evidence in this action without disclosing that it was negotiated and agreed. To complete his bad faith gambit and continue harassing Jane Doe and the Busby parties, Carter commenced a new lawsuit in Alabama against Jane Doe and the Busby parties and others on March 3rd, 2025. After obtaining a delay on the motion by claiming the discovery of new evidence. The court should not ratify this obvious gamemanship. It is clear that Carter's purpose is not to advance a meritless claim, but to intimidate and harass the Busby parties through an abuse of the legal process in multiple jurisdictions for the reasons stated in greater detail below and in the special motion to strike. The application should be denied, and the special motion to strike should be granted in full and with prejudice. Now, this is crazy. This is effing crazy. Black Gold said, I don't trust Spiro at all. No shade, but his eyes are shifty and he talks fast. I don't trust him. Something very cold calculated about him. Exactly. I never trust that man. I never trusted that man. Ooh, nah, I ain't gonna say that here. Y'all gotta go to the 6 o'clock video. Your favorite player legal has been busy today. Thank you for tuning in. Thank y'all for tuning in. Another judge is taking issue with Tony but lack of admission. We're gonna get to that in another video. I'm trying to kind of separate this whatchamacallit. At the end of the day, the ball is in the courts. He already submitted his pro hoc vice. It is up to the court whether or not they approve it. So the ball is in their court. We don't know until the judge figure out what they're going to do. But he has to file a pro hoc vice in each case that he has done. All right, going to the relevant backgrounds. Let's get this because we got about 30 minutes to cover all this up. So, relevant background, the application asserts that there is sufficient evidence for the tier of fact to conclude that Mr. Busby convinced Jane Doe to assert untrue claims against Carter on December 11th, based on Jane Doe's alleged statements to two investigators who mysteriously claim not to have been retained by either Carter or his attorneys without identifying their employer on February 21st, 2025. And in my last video last night for those two Louisiana cases and the Houston cases, I believe that these people were probably hired by MJ Legal or Marcy Croft. They all in cahoots. Or Quinn Emanuel. They all in cahoots together. A demand letter and commencement of the New York action. In October, Jane Doe was referred to the Busby parties in connection with potential claims against, among others, Carter. Jane Doe had identified Carter as the litigation target to the referring attorneys. The Busby parties conducted diligence on her claim, including her claims against Carter in October of 2024. On October 20th, 2024, the Busby parties filed on behalf of Jane Doe a complaint in the New York action attached to Carter's opposition. Okay, we already know that. We know about the complaint, right? All right, he was first identified as Celebrity A. November 5th. And y'all know I've given y'all this timeline. I gave y'all this timeline. Remember on the spreadsheet or the PowerPoint? November 5th, 2024, with a complaint based on Carter's alleged conduct already pending in the New York action, because remember, he was Celebrity A. The Busby party sent Carter a demand letter on behalf of Jane Doe, which she authorized. Okay, and we're going to look at Busby's declaration, David Fortney's declaration, and the other declarations. On November 18th, Jane Doe executed an affidavit in support of her allegations in New York, identifying Carter as Celebrity A. December 8th, Jane Doe executed a second affidavit in support of her allegations in the New York action. Y'all see where we're going with this? Affidavits. Affidavits. It's the same thing as if you are on stand testifying. It's just on paper. Spiro always looks nervous and he always lying. He does. Now, Kwame, that is a very good question because I did I did first think that these individuals were from Diddy's camp, but I don't believe so. Spyro has came out to say that, and he doesn't say that. See, he can't keep his lies straight because if we go to the Texas cases, when Busby actually sued Quinn Emanuel, he admitted that they have private investigators. A little do y'all know is that Tupac's, and I said this in my video, but I might as well say it now. Tupac's family actually hired Alex Spiro to investigate um the wrongful death of, Tupac, right? And now it makes sense because if Jay-Z has Quinn Emanuel as their, attorneys and Alex Spiro is his, his go-to man, it explains the reason as to why Spyro was trying to separate Diddy and Jay-Z, saying that they're not friends. They were just business associates. I don't believe that this is Diddy's team. I strongly believe that this is Jay-Z's doing. This is Quinn Emanuel's doing because any case that Jay-Z is on, any case that Quinn Emanuel is on, private investigators are everywhere. Take away Jane Doe case, the Ramir case, the young man that looks like Jay-Z. Investigators went to his godmama's house. Leon Black, who actually assaulted a model. This is not even Jay-Z case. Private investigators showing up at the ex-model's home. Why are you showing up? You are the defense counsel. Why are you showing up at the plaintiff's home? Let's come to Texas. Garcia. Geraldo Garcia, Jose Maldonado had Jessica Santiago come to their, like, literally harass them, stalking them, their family, trying to figure out where they are, specifically saying such and such hire me. You want to join this class action suit against Busby? Then drive straight to Louisiana. Two people coming against Busby saying that he misappropriated their funds, but they signed a contract that outlined what the fees were. They set out the settlement memo that shows how much they were getting back. They signed a contract that says if you have a problem with any of the legal services or the fees, you have to do arbitration first. Going all the way back to New York, where Claudia Brady talk about Tony gave her a venereal. Y'all don't get the picture. They're trying to tear this man down. They're trying to ruin his image. Alex Spiro has always done this. Look at the Eric Adams case. The judge specifically had to tell Alex Spiro to keep his tail off of the news. Because he was actually going to talk about Eric Adams. He didn't do this. They're just trying to bring him down. Blase, blase, blase. That's what Spyro does. He tries to use the court of public opinion. Some say Busby, might do so. And I get it. But Spyro been moving shady. People just stuck on this Jane Doe case and not opening their eyes to other cases that Quinn Emanuel has their hands on. Spyro said Jay-Z friends hired them. Then they admitted defiant. No, they're crooked. Yep. I think all the investigators that had to pop up are his. They are. They are. When I heard Tupac's family hired Spyro, I said, nope. They trying to get all the dirt to put the nail on Diddy's. Man, what? I think they shared goons, but like they said, they are Team Rock. Man, let me tell you something. Nope. That is why Busby. Well, you're talking about the investigators. Well, here, check this out. So Jose Maldonado and Geraldo Garcia, the two Texas cases that Busby filed on their behalf, it is a crime for barratry. You cannot go. But see what they were doing, they were trying to go and get dirt on Tony Busby and say, hey, if you file this lawsuit, we'll give you 10 G's, 1,000 G's, or whatever. So that part is a crime because you can't do that. Another part of what was a crime was them saying, oh, we're with the state and flashing fake badges. That's a crime. But being an investigator, no, that's not a crime. That is not a crime. It is very much legal. Hell, we use them. All right, back to this. Let me see. The resolution of the New York action and Carter's subsequent game playing. The special motion to strike was filed on January 17th, 2025, and set for hearing on January 25th, 2025. Carter did not move for discovery prior to hearing. Y'all have to make sure I have a whole playlist of the Tony Busby saga, and they're in order. So you have to make sure that you understand, because it's hard for me to kind of go back and tell y'all about each one when I've already spoken about that. So on February 4th, after discussions between Carter's attorneys at Quinn Emanuel in New York and the Busby Party's New York counsel Mark Kasowitz, Trump's attorney, an agreement was reached confirming certain terms, which included the dismissal of the New York action, a commitment by Carter and his attorneys that they, and it's in bold. Let me blow this up because some people just run with anything. It said, so the agreement between Quinn Emanuel and Trump's attorneys, Mark Kasowitz, said the following: Carter's and his attorneys will not authorize, employ, or other engaged investigators or anyone else to harass or otherwise interact with my client, his firm, or his present and former clients, employees, and family. In other words, you're not going to hire investigators to continue to harass Tony Busby, Tony Busby's firm, any of his clients, any of his former clients, any of his employees, former employees, nobody. It is right here in bold. So Quinn Emanuel and the Castlewit firm made an agreement, and he put in a clause that Quinn Emanuel cannot hire investigators. So Jane Doe follows under clients. But yet, what did they do? She just, let me keep reading. Let me just keep reading. So that's that. That's the agreement. That's the agreement. Are we gonna follow to the block cases where Jay's? Yes, and that I'm gonna cover that, but the shareholders are the ones, and I'm gonna break that down because now I gotta pull out my MBA degree and explain that. So yes, we're gonna go over that. If Jane Doe was pressured into dismissal, why didn't she contact her attorney Busby and could file a grievance that your client is being pressured to taint the ruling? She wasn't pressured into the dismissal. She felt like she wanted to do the dismissal because, as she stated in her declaration, she did not want to be harassed. But at the end of the day, now that they have confirmed that there was an agreement and they broke that agreement, I'm pretty sure there's more lawsuits that's going to be filed. And Trump's attorneys don't play. They already told you once there was an agreement, and Quinn Emanuel broke that agreement. So I'm ready for all of this. On February 4th, 2025, Carter withdrew his Rule 11 motion. On February 14th, Jane Doe and the Busby parties dismissed the New York action in reliance on the understanding reached between Mr. Kasowitz and Quinn Emanuel that the parties would de escalate and discontinue their litigations. It's there right there. February 21st, just 1 week later, investigators appeared on the doorstep of Jane Doe. Notwithstanding the existence of a negotiated agreement that specifically precluded Carter, his attorneys, and his agents from harassing or even interacting with her. The investigators' declarations suspiciously avoid identifying their employer. That's exactly why Miss Charlotte Henderson, I'd call her because she's also a certified paralegal And take out the investigative part of it. Ma'am, you are a paralegal. You knew what you was doing was not right. Now you are implicated in this whole saga. I don't even feel bad at this point. I don't. And I won't be surprised if something was filed against her in the state of Alabama for what she had a part in. I don't think Jay-Z gonna save you, ma'am. And that's a bad reputation on your private investigator company, let alone you being a certified paralegal in the state of Alabama. On February 18, 2025, Carter's counsel at Quinn Emanuel filed a request for judicial notice of the dismissal of the New York action, asserting that it was probative of the issues on the special motion to strike. Now, here is the 25th, the hearing that I was talking about. At the hearing on the special motion, counsel for Carter again attempted to make an issue of the negotiated dismissal, arguing that it offered evidence of falsity and recklessness because the Busby parties dismissed it voluntarily without prejudice. Sir, you had an agreement with Trump's attorney to dismiss it. And in that agreement, you stated that you were not going to hire, well, you didn't state it, but you agreed not to hire any investigators to go harass anybody. But now you're trying to use that. So everybody is so gung ho on the part. Well, Jane Doe, she dismissed her case with prejudice. Why she didn't do this? Why she didn't do that? Do y'all not realize what was just said? They had a negotiated dismissal. She was tired of being harassed. It's one thing for nobody to know who you are, so you don't have to worry about people harassing you from the public. But they were still harassing her, calling her a liar and all this other stuff. But I can only imagine that at this time, they already knew what her name was. They already knew. They knew for months. I'm pretty sure October, let me see, between October and December, they knew who she was. And that's exactly why they put that clause in that agreement. If you agree, if you agree to dismiss this case, I will agree not to mess with your client. But yet, here, the Quinn Emanuel Alex Spiro is trying to use that dismissal as evidence that it was a false claim. Epstein already told y'all at this meeting that just because a case was dismissed does not mean that the allegations are not true. People need to understand that. Moral turpitude. Yes, it is. Moral turpitude. And one thing we ask in discovery, have you ever been charged with moral turpitude? A lot of people don't understand what that is. Y'all better Google it. Counsel for Carter did not disclose that this was the result of a negotiation. That's crazy. So everybody out there to be like, oh my God, Jane Doe dismissed her case. She must been telling a lie. She's a liar. That's why she dismissed her case, because she was lying. Da 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 da. No, it was based off a negotiation. They agreed. She was tired. Who wants to sit here and be harassed? They were not only harassing her, they were harassing her family. Let's take Jane Doe out the picture. How about all the other people who have been in the path of Quinn Emanuel who have been harassed? Who seriously wants to deal with that? Go ask Jose Maldonado or Geraldo Garcia or the ex model, or hell, even the parties in the freaking Cologne place that sued Jay-Z. Go ask those people how it feels to be harassed by an investigator. Y'all people sound stupid. The case was dismissed. It was a negotiation. And Spiro failed to relate that to the California court. It wasn't dismissed because Jane Doe was lying. It was dismissed because they came to an agreement. She did not want to continue with all this bickering, all this harassment. That's why they came to that negotiation, that agreement. The court astutely rejected that argument and observed that it might have happened because Jane Doe said, "I do not want to have to go through a firestorm I'm going through." This is exactly what had happened. At the I'm about to say November, at the February 21st, 2025 hearing, Carter's counsel represented to the court that his office had just the morning been made aware of new evidence. Now, this is the 25th. This is where the judge said, "I'll give you 10 minutes to call the investigator so I can get more information." But guess what? The attorney said, "No, no, I can't do that because they're going to give me information that you don't want to hear." Mm. Anywho's, let me stop pausing. At the February 25th, 2025 hearing, Carter's counsel represented to the court that his office had just this morning been made aware of new evidence and requested a continuance of the hearing to the following Monday. Counsel was unable to provide any detail on the nature of the new evidence. That new evidence was later revealed to have been obtained 4 days earlier when Charlotte and James cornered Jane Doe on the steps of her home on the porch, wanting her to sign a freaking affidavit. Now, even though the affidavit thing that I'm doing, it's after this, y'all just got to go back and watch it. But yeah, that's the new evidence. See, he was banking on Jane Doe signing that affidavit. Matter of fact, I don't even say he was banking that Charlotte Henderson and James Butler would pressure Jane Doe into signing that affidavit. Because if she would have signed that affidavit and they would have submitted it in this case, Busby is cooked. Plain and simple. The case is over with. That's what he was banking on. Just watch that video after we done. At the court's direction, counsel for Carter and counsel for Busby parties met and conferred telephonically the following Friday, February 27, 2025, regarding the proffer of new evidence. Counsel for Busby parties requested a description of the new evidence at issue. Counsel for Carter advised that she could not provide any additional detail, but suggested that she would be able to do so on the following Monday. The meet and confer was rescheduled to the Monday, March 3rd, 2025, only to be canceled again that Monday by Carter's counsel. Ooh, that boy, I swear, I'm so glad they put this together because this is the same crap I be thinking. Yes, Alice. Girl, they brought an affidavit that was already typed and told her to sign it. That is funny. Like what? Spiro said at the first press conference that he already knew. He already knew. Was dropping the sanctions a part of the negotiation or just the high? No, drop it. So he pretty much said drop the sanctions, drop the case. So it was like a back and forth. So they says, okay, y'all drop the sanctions, and then we'll drop the case. And if we do this, then y'all don't mess with her or Busby or any of his clients' family, blase, blase, blase. No, girl, Alice, girl. Ooh, y'all gotta tap in later on. They tried to get her to sign it, meaning that they probably already typed up something and was trying to get her to sign it, girl. Girl, y'all got girl. At the court's direction, oh, you already read that. Oh, girl, yes, yes, yes. Okay, on Monday, guess what happened? Wait, hold up. Did I read that? Okay, yeah. On Monday, March 3rd, 2025, the Busby parties learned from media reports that Carter had filed a new lawsuit in the district court in Alabama against Mr. Busby, his firm, another attorney from his firm, and Jane Doe. The Alabama case alleged that Jane Doe, through Busby, sent Mr. Carter an extortionate letter dated November 5th, 2004. Oh my gosh. Oh my gosh. This is crazy, y'all. The timeline establishes that the theory advanced by Carter's new evidence is uncontroversibly false. The court is not required to accept new evidence lacking in evidentiary value or draw conclusions that no reasonable fact finder could draw. It is well settled, for example, that a court may disregard evidence that contradicts prior admissions and is not required to accept an unreasonable characterization of the factual record. Let me see. Let me highlight this. Self-serving declarations that belatedly and obviously contradict a verifiable fact record cannot be used to salvage claims that lack merit as a matter of law. Carter's new evidence lacks probative value. Carter and his attorneys assert, based on entirely on investigators' characterization of unsworn hearsay, that Jane Doe was persuaded to make up a claim against Carter by Mr. Busby for the first time on December 11th, 2024, after she had already been referred to the Busby parties to prosecute claims against Carter, after she had already filed complaints based on Carter's conduct twice, and after she had executed affidavits naming him as the perpetrator of sexual assault twice. Not only is that directly refuted by testimony from Jane Doe and others, but it is a literal factual impossibility and thus has no probative value. Nor can it be squared with Carter's allegations in the Alabama case that he was always her target and had been sued by her already on October 20th, 2024. Worse, the circumstances of Carter's new evidence suggest undue influence and intimidation consisting almost exclusively of unreliable and provably false hearsay. Hearsay. There can be no reasonable difference of opinion that Carter was a litigation target and was already the subject of litigation by October of 2024, that the demand letters were sent in the context of an already pending litigation, or that Jane Doe had authorized her claims against Carter prior to December 11th, 2024. The court is not required to close its eyes to the reality in the undisputable timeline. Accordingly, the court need not give any weight to Carter's new evidence, because Carter's new evidence is hearsay. It is boo-boo. That's why the evidence that was submitted by the investigators is inadmissible. Carter's new evidence is also inadmissible hearsay. According to California Evidence Code Section 1200. Carter urges that Jane Doe alleged statements were a declaration against interest under Evidence Code Section 2030. This argument fails. Only, and I want y'all to pay close attention to what I'm about to read, only a statement that is so against the interests of the declarant that no reasonable person would utter it qualifies for this exception, and most, if not all, of the purported statements at issue here fall short of the standard under the circumstances. There is no evidence, for instance, that the Jane Doe would have understood the statements to be against her interests. Indeed, the statements attributed to Jane Doe by the investigators attribute misconduct to the Busby parties, as they must for purpose of opposing the motion, not Jane Doe. Such statements are not clearly against Jane Doe's interests. Moreover, in assessing whether a statement falls under or within this exception, courts place a heavy emphasis on both the statement and the circumstances with a focus on whether the statement has sufficient indicia of reliability. And they cited People versus Schuon. I hope that's how I'm saying it. But it's saying finding that statements were not within the exception where they contradicted other statements were made after the passage of time, and the declarant was generally not credible, and noting that even when a hearsay statement runs generally against the declarant's penal interest, the statement may, in light of circumstances, lack sufficient indicia of trustworthiness to qualify for admission. Everything about Charlotte Henderson's declaration was outrageous. Then they copied and paste. They ain't even copy and paste. They just took Charlotte Henderson's declaration, and I don't even know how they did it. Cut and paste the language for James Butler and just pasted right on that same document and changed two words and called it the Declaration of James Butler. Identical declarations that are hearsay. We gotta think procedure. That's why I keep telling y'all, take the Jane Doe, the Jay-Z, the Tony Busby, and just think regular people. This is not how we do things in the legal world. Quinn Emanuel is losing. Jay-Z is losing. They are sinking. They are about to go under like the Titanic. And they're trying to do everything in their power to stay afloat. And it's not working. They are sinking. They're sinking slowly, but they're sinking. Here, there is overwhelming evidence of a lack of reliability of the pro offered evidence. For one thing, Jane Doe flatly denies the statements set forth in the investigators' declarations. As noted above, the timeline being advocated by Carter is also incoherent and easily disproven by reference to undisputed and undisputable facts. The evidence further establishes that Jane Doe was and remains frightened to retaliation and harassment from Carter and was ambushed by two investigators at her home only a week after she had, as part of a negotiated deal, dismissed her claims against Carter to make such harassment stop. That's all she wanted. She said, I am tired of the harassment and I will agree to drop this suit if y'all agree never to harass me again. Thank you, Quilts and Chocolate. That was the deal. And as soon as she dropped her lawsuit, guess what? Guess what the narrative then was? Oh, she definitely was lying. Not knowing, you think Spiro was going to come out here and say, "Oh no, we negotiated. I said I'll drop the motion for sanctions, and I'll stop harassing Tony Busby and his former clients and his family members, if they go ahead and just drop the suit and you think he going to come out and say that? No. That's why I love when I see oppositions and I see declarations. I'm a plaintiff's person. I do plaintiff's work, and we have to work extra hard to ensure that we're putting out correct and accurate information. That's why I tell you guys the process. See, when you're on the defense side, you got to do anything by any means necessary to stay afloat. I'm like, what is all these alerts coming? Um Further, the investigators' own declarations indicate that Jane Doe abandoned her lawsuit against Carter because she thought Carter would unalive her or otherwise retaliate against her. Mr. Busby told Miss Doe that Mr. Carter was threatening to unalive her in response to her lawsuit and could come after her. That's untrue. But regardless, the investigators' own declaration suggests that the statements they claim to have obtained were made by a frightened woman to agents of a man she thought capable of unaliving her. Any statements given by a woman who is supposedly an anonymous alleged victim of sexual abuse and who is frightened of retaliation made by two investigators who unexpectedly appeared at her home are inherently unreliable. Intimidation is inherent to such a situation. The investigator's own declaration likewise indicate that Jane Doe refused to sign an affidavit, which further undercuts any supposed reliability. Further, the sequence of events pro-offered by Carter is questionable. According to Carter, Jane Doe conspired to prosecute a false claim, signed multiple sworn declarations affirming this false claim, vigorously defended the false claim to the media, and submitted declarations in this action affirming it again, only to voluntarily admit that she made it all up. As the two investigators surprised her at her home just in time for the hearing on the motion for January 25th. I'm like, y'all, how convenient. How convenient. This theory suggests either intimidation or falsity. Either way, any statements extracted under these circumstances are not liable. There are two additional supposed details of the encounter between Jane Doe and the investigators that raise serious concerns, both as the reliability of the new evidence and Carter's pattern of conduct. First, the rules of professional conduct prohibit attorneys from making direct or indirect contact with a represented party. Do y'all hear that? The rules of professional conduct prohibits attorneys from making direct or indirect contact with a represented party. While the investigators do not disclose who retained them and sent them to Jane Doe's home, a troubling omission, it can reasonably be inferred that they were acting on behalf of Carter or his agents. This right here is like, I think a 2-year old can understand what I just said. You submit a declaration that stated that Jay-Z nor any of his attorneys hired you, but yet you submit a declaration to support Jay-Z. Can, 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 how does that make sense? In no way, shape, form, or fashion, I said this in the video, can a private investigator come to our office and say, "Here, Cassandra, here's a declaration. Please file it to support your motion, your pleading." And I'll be like, "Okay." No. I'm going to be like, "I didn't hire you. I'm going to get on the phone with my attorney." Thank you so much. Thank you so much, Black Gold. Oh my gosh. Thank you for the super chat. I had to give you a tip for the wonderful work you put in today to break this down for us. Thank you so much. Thank you so much for the super chat. Thank you so much. But if somebody come to me and says, "Here, Cassandra, here's my declaration," and I'm not even saying someone, if an investigator that I didn't hire, I'm gonna get on the phone, I'm gonna call the attorney, like, "Hey, did you hire this investigator?" And he gonna be like, "Nah," and I'll be like, "Well, I'm sorry, I can't use this declaration. You weren't hired by neither party or counsel of record." So I don't understand why people think that declaration was BS. I don't care what the contents of that declaration is. The fact that you're going to say I wasn't hired by Jay-Z or anybody in the firm, but yet they're going to take your declaration and they're going to use it to support their pleading. That's sus. In the words of my kids, that's sus. That's what that is. That's called sus. That is suspicious. Second, only a couple of isolated statements in the investigators' declarations appear in quotations. Only a few. If y'all don't know, anytime somebody, if you're going to make a declaration, at least everything that Jane Doe said should have been in quotations, not you summing up what she said, not you, rephrasing what she said. Only some were in quotations. And those were mainly one word answers to leading questions posed by two investigators who surprised Jane Doe at her home. Otherwise, the investigators just present facts that Jane Doe supposedly, I'm doing air quotations, confirmed without reciting the words that she supposedly used to confirm those statements. These are not reliable facts. At best, that is a mere characterization of an otherwise undocumented conversation by two investigators lacking personal knowledge of the events being discussed. Because did y'all, whoever hired y'all, fail to tell y'all that y'all wasn't supposed to go harass this girl because it was already in an agreement? So I pray that Jane Doe files a suit against Quinn Emanuel, against these investigators, and everybody who are in cahoots, because and I hope that Trump's attorneys just do it pro bono and eat they ass up. I'm an hour in. I hope he eat them for breakfast. This is the only time I support anybody that deals with Trump. That's Tony Busby and Casowitz. Tear them up. Oh my gosh. Let's see. At worst, given Jane Doe's denial of the substance of the conversation, it is knowingly inaccurate description of the investigators' interrogation of Jane Doe, which was conducted in violation of the California Rules of Professional Conduct, and the parties negotiated ceasefire to intimidate and harass an alleged sexual assault victim and her counsel. Either way, the hearsay statements attributed to Jane Doe by the investigators are not admissible admissible admissions against interest. Carter's reliance on Sweetwater. So this is anytime y'all hear Sweetwater, this is the case that they are referencing. So Sweetwater Union High School District versus Gilbane Building Company is obviously misplaced. Sweetwater merely addressed otherwise admissible evidence contained within testimony and concluded that the court may consider statements that are equivalent of affidavits and declarations because they were made under oath or penalty of perjury in California. I keep telling y'all this, and I'm glad that they say it in here. Inadmissible material contained within such documents, such as hearsay, may not be considered. This is that 25th meeting on February 25th. This is what they were going back and forth with. And so that's why I said they were banking on Jane Doe not being in her right mind or either being punked into signing that affidavit, and it didn't work. And I bet you they probably tried to go after her after the 21st too. They probably were still stalking her. Let me see. At 2049, it says if the evidence relied upon cannot be admitted at trial because it is categorically barred or indisputed factual circumstances show inadmissibility, the court may not consider it in the face of an objection. Whew. Child. Plaintiff misreads Sweetwater. The case reaffirmed that hearsay, absent an applicable exception, may not be considered for anti-SLAPP purposes. The only examples of curable hearsay in that decision were made under oath and penalty of perjury. Let me see. Carter, other new attacks on Jane Doe are irrelevant. Let's get through this. So Carter also submits the Pillinger Declaration. So y'all know Ian Pillinger. If y'all have not, I think it's the more declarations video that I did. So Ian Pillinger is a he has a business where he does private investigations, he, do background checks, all of that. So he is the one who found out her medical history, the other lawsuits that she was in, the whole 9 yards. All right? That declaration is entirely lacking in a foundation and Oh, wait, let me go back. Carter also submits the Pillinger Declaration claiming that Jane Doe has a history of psychological problems and has encountered difficulty with the law. The declaration is entirely lacking in foundation and personal knowledge. Moreover, even if true, it is irrelevant. Apparently, Carter is of the view that people alleging sexual assault should have flawless psychological profiles without any psychological damages or past legal problems, and if they don't, are unworthy of representation of legal redress of their grievances, a position that might require Carter's attorneys at Quinn Emanuel to abandon their representation given his own reported history of brushes with the law. Oh, I love that right there. So what they're trying to do is they trying to make her seem like a criminal. They're trying to make it seem like she just ain't in her right mind. That's like you're discriminating. If a client came in here right now and said, I've been in a wreck, or I slipped and fall in Kroger, or whatever the case may be, I need representation. One thing I do, I actually do a background check on them. Because what happens is we'll take their case, but we're not going to hold that against them. We never hold that against them. But the reason we have to know this is because what happens when you get to depositions, now I've seen it in car wreck cases. The defense counsel will bring up, well, I seen you went to jail for theft. What does that have to do with my client being in a car accident? What they try to do is they try to diminish the credibility of the plaintiff. They try to make them feel as if because I'm a criminal, I have a past, or I have mental issues, that I'm not credible, that I'm making up this whole story. What does me stealing a $2 pack of gum got to do with me being in this car wreck? Nothing at all. So I say this to say, just because she has a history with the law, because she has mental issues, that should not say that her story is false. They do all of these things in order to bring them down. Look at what Spiro and Jay-Z was doing to Busby. They made Claudia file a lawsuit in New York saying that he gave her a venereal disease. They sought people. They have investigators going to people like Geraldo Garcia, Jose Maldonado, other family members, other former clients, current clients, former employees, trying to get dirt on Busby so they can tarnish and diminish his credibility. That has nothing to do with the matter and the issue at hand. This evidence is not relevant. It does not disprove Jane Doe's allegations, nor suggest that the Busby parties doubted her veracity. The law does not require plaintiffs to be perfect before they are entitled to seek relief from the courts, nor does the law preclude lawyers from advocating for individuals with disadvantages. Carter's pro-offer of this evidence is hypocritical and cruel. I'm dying. Jack said those Timu investigators was hired by Timu. Child. I'm really upset with Charlotte Henderson for the fact she is part of the paralegal community. And for her to even take place in this whole ordeal, I'm just very curious as to what will happen to her. The new evidence fails to salvage Carter's frivolous claims. The litigation privilege applies as a matter of law. This is stuff that the judge has already spoke to Jay-Z's attorneys at the freaking hearing on the 25th. So he's just reiterating everything that the judge has already said. He talked about Sweetwater. He talked about the litigation privilege. He talked about a lot of stuff. He talked about the hearsay. Anywho's, as a matter of law, the litigation privilege bars Carter's claims for extortion and intentional emotional distress. Both claims are premised on demand letters requesting mediation that were sent to Carter after a complaint was already filed in a New York action, which included the specific allegations against him by Jane Doe. An amended complaint was soon thereafter filed to identify him by the name. The demand letters are core litigation conduct, and no finding to the contrary can be sustained. Carter's attempts to manufacture a dispute about whether the demand letters were properly authorized and nonsensical for the reasons noted above. In fact, the demand letters were appropriately authorized and were sent in the context of active litigation. In any event, under the circumstances, the issue is besides the point. The litigation privilege is absolute, and communications made in connection with litigation do not necessarily fall outside the privilege merely because they are or alleged to be fraudulent, perjurious, unethical, or even illegal, assuming they are logically related to litigation. The Busby parties are and were Jane Doe's attorneys. They were retained to pursue claims against Diddy and Carter. They filed the New York action on behalf, referred to Carter in the pleading on her behalf, demanded mediation from him, and then identified him by name in the First Amendment complaint. Their conduct falls squarely within the privilege. Carter's reliance on people, XREL, the Fire Insurance Exchange versus Anapol, is misguided and misleading. Anapol involved the submission of insurance claims which are not privileged. In response to a special motion to strike, the attorney who had submitted insurance claims signed a declaration acknowledging that the claims were an attempt to obtain payment without litigation, but then later executed a declaration attempted to argue that the claims were submitted in anticipation of litigation because he expected them to be denied. The court explained that in light of the prior declaration, his subsequent declaration to the contrary cannot constitute prima facie evidence of the anticipation of litigation, and that an insurance claim cannot be transformed from a simple claim for payment submitted in the usual course of business into protected pre-litigation conduct solely on the basis of the subjective intent of the attorney submitting the claim. The court also noted that there was no indication that the client had anticipated litigation. This case bears no semblance to Anapol. This case always involved a contested litigation matter. There is no question that litigation was anticipated. A lawsuit based on Carter's conduct had already been filed when the demand letters were sent out. So, in other words, y'all can't say, y'all have to understand, Jay-Z, even though he was not named per se in that October 20th lawsuit, Celebrity A was a placeholder. They just wanted to sit down, have a mediation, and Jay-Z declined. So that's why the amended complaint was updated to include his name. The demand letters were not extortion, as the judge has already stated. Even without privilege, the extortion claim fails. As a matter of law, the mere threat to file a lawsuit is not extortion. That is the only threat that can reasonably be said to have been made against Carter. Carter has presented no evidence, for instance, that the Busby parties offered to refrain from making a criminal referral in exchange for money because they did not do so. Thus, Carter has failed to present evidence of a wrongful threat, and his claim fails at the threshold. I say this in every video. Y'all been with me long enough to know the plaintiff, the petitioner, bears the burden of proof. What proof does he have that says Jane Doe is a liar? Hmm. Nor has Carter established that he paid anything in response, in which he did not, which is separately fatal to his extortion claim. So, did you pay anything? Now, you did put out a statement that says you're not getting one red penny or cent or whatever, but the demand letter didn't even ask for money. It asked for a confidential sit down because allegations was already out there. And instead of us naming you in this lawsuit, we want to sit down and ensure that this allegation, like, let us make the determination whether or not we're going to include you in this lawsuit. Because she's already told back in October what was going on. So, whatever new evidence he has, it fails to overcome either of those defects that I just mentioned, and the motion must be granted as a matter of law. So, bro, just strike the whole goddamn amended complaint. His defamation claim fails. First, as a matter of law, statements A through and including D are not of and concerning Carter and cannot be the basis of a valid cause of action. The argument to the contrary relies essentially on the premise that weeks after the statements were made, Carter filed this action anonymously in a tacit admission that no one understood prior statements to be about him. So, why did you sue? Why did you file a lawsuit under the pseudonym John Doe? Let's make this make sense. This is funny. And that Mr. Busby liked the post in late November that identified Carter as the plaintiff in this action. There are numerous flaws in that argument. A statement that was not actionable when uttered cannot become actionable later based on a subsequent events. California law requires that the court consider the full context in which a statement was made in determining whether it is of and concerning a plaintiff. But this contextual analysis inquires whether the statement's audience would reasonably understand it to reference the plaintiff. Because everybody was saying everything. I didn't even think it was Jay-Z. People were saying it was Kevin Hart and all this other stuff. So in Dickerson versus Cosby, okay, similar situation. It says that the plaintiff must show the statement expressly mentions her or refers to her by reasonable implication and was understood by at least one third person to have concerned her, which requires examination of the nature and full content of the communication and the knowledge and understanding of the audience to whom the publication was directed. Statements A through D make no mention of Carter and could not reasonably have been understood by their audience to refer to Carter. Because, like I said, I didn't even think, I was thinking it was somebody else. No California case has been cited for the proposition that the court can consider events that were not part of the context in which a statement was uttered to render it of and concerning a plaintiff after the fact. Such a rule makes little sense. A statement is either defamatory when uttered or it is not. Moreover, the like did nothing more than arguably identify Carter as the plaintiff in the lawsuit. It did not render past statements that were general in nature about Carter specifically. So Carter's new evidence changes none of this. Let me see. Likewise, as a matter of law, statements A and D carry no defamatory meaning about Carter. Each of the statements is posed in general terms of opinion about the accusations against Diddy. The statements comment that numerous people were in some way responsible for aiding and facilitating actual misconduct by Diddy, and that such people should be held accountable. But none of these statements can reasonably be construed to mean that Carter specifically or any identifiable individual was responsible for any specific identifiable wrongful action. Statement A, I want to make sure I capture a wide net and capture everybody involved. Didn't mention, no mention of Jay-Z there. Statement B said, I expect other people will be implicated. So I think that, like I said, I think we're only seeing the tip of the iceberg here. Once again, nothing about Jay-Z. Statement C, references to potential defendants that would raise some eyebrows and to defendants that might be a bank or a pharmacy or a hotel or a club. Statement D says it may not be big names at first, but we have a long list of names. None of these statements conveyed anything specific to Carter or the allegations against him, nor can they reasonably be read to convey a specific fact about any specific individual. No reasonable listener could have understood statements A through D to convey anything defamatory about Jay Z. Now, statements E and F arguably relate to Carter but carry no defamatory factual meaning. At most, they are opinions and combative rhetoric in an adversarial setting. Statement F consists of nothing more than a generic statement that what happens next is up to my client. So this was just kind of going over the defamatory portion of it. We ain't go through all of that. Hush, whatchamacallit, because I really wanted to cover the new evidence that they're claiming they had. All right, he fails to establish whatchamacallit. And this is another thing, the $20 million per year. That is funny to me. They reference media reports are classic hearsay and speculative on their face because what evidence do they have that he was about to lose $20 million per year? He didn't submit anything. I have not seen anything yet in this filing, in a California filing, or any filings for that matter, that said that Jay Z was going to miss out on $20 million per year. That's crazy. All right. So this is what y'all wanted. Let's see. So this is the declaration of Tony Busby. So Tony Busby shows the declaration that Jane Doe submitted. I am the plaintiff in the above captioned action identified in the complaint as Jane Doe. I make this declaration in order to verify allegations made in my complaint. The statements made herein are based on my personal knowledge, and if called as witness, I could and would competently testify under oath as the facts herein. So this is, I believe, this is the first time when she, this is about, okay. So this is what she executed November 18th, 2024. This is prior to her admitting the complaint to add Jay Z. So this is what she stated. She said that on or around September 7th, 2000, plaintiff, then 13 years old, had a friend drop her off at Radio City Music Hall in New York City so she could try to attend the Video Music Awards. Plaintiff arrived at the venue and saw large crowds gathering as artists and entertainers began arriving. As the event began, the crowd moved inside, but plaintiff, without a ticket, remained outside. Determined to get into an after party, she approached several limousine drivers, attempting to talk her way into the VMAs. One of the limousine drivers she spoke to claimed to work for defendant Combs. She told her that Combs liked younger girls and said she fit what Diddy was looking for, not allowing her into the awards but invited her to the after party. The driver instructed plaintiff to return about 9:30, 10 p.m., promising to take her to the party. Later that evening, plaintiff excitedly returned to the driver, who drove her alone in a black limousine with black interior. After approximately 20 minutes, plaintiff arrived at a large white house with a gated U-shaped driveway. Once inside, two men asked plaintiff to sign a non-disclosure agreement, informing her that she could not discuss what happened at the party. She gave them her name and signed the form, but did not receive a copy. Inside the house, plaintiff recognized many celebrities in what appeared to be the living room. Wait staff, hush. Wait staff carried trays of drinks and loud music played throughout the house. Plaintiff observed widespread rug use, including Mary Jane and Becky. Plaintiff accepted a drink, a reddish yellow mixture that tasted like orange juice, cranberry juice, or something bitter. After drinking just one drink, plaintiff began to feel woozy and lightheaded, making her need to lie down. A photograph of an actual exemplary container used by Combs and or his agent's employees is insert GHB into alcoholic drinks is seen below. Oh yeah, I remember that. You have to go back to the original complaint. Looking for a place to rest, plaintiff entered what she believed to be an empty bedroom so she could lie down for a moment. She did not lock the door. Soon after, Combs, along with a male and female celebrity, entered the room. Combs aggressively approached plaintiff with a crazed look in his eyes, grabbed her, and said, "You ready to party?" Combs then threw plaintiff toward another male celebrity, Celebrity A, who removed plaintiff's clothes as she grew more and more disoriented. Plaintiff was held down by Celebrity A, who raped her while Combs and Celebrity B, a female, watched. After the male celebrity finished, Combs then raped her while Celebrity A and Celebrity B watched. Combs attempted to force plaintiff to perform oral on him, but she resisted by hitting Combs in the neck, and he stopped. Plaintiff grabbed her clothes and shoes, left the bedroom, roaming naked throughout the house, looking for an exit as the party continued. Once outside, plaintiff put her clothes back on, left the scene in the dark. Eventually, plaintiff reached a gas station. A female clerk noticed her distress and allowed her to use the phone. Plaintiff called her father, admitted that she had lied about her whereabouts, and asked him to pick her up. After the assault, plaintiff fell asleep into no, I said asleep. Plaintiff fell into a deep depression, which continues to affect her facet of her life. In the allegations above, Celebrity A is Jay Z, known as Sean Carter. In the allegations set forth above, Celebrity B is, ooh, I wish that was not redacted. Darn, I wish I could remove redactions. God diggity dog. I'm gonna work on that. I recognized all defendants Combs, Jay-Z, and Blank immediately when they entered the room in which I had been laying down because I had left the light on. Now this, hold up. Well, no, because the petition was filed in October. Okay. But yeah, so this was filed. This was executed on December 18th. So that's before it was amended. Then she amended the complaint and same thing. Trying to think. I think she probably oh yeah, so they added a little bit more stuff. Let me see. Hold up. I ain't gonna read all of this. She felt woozy, looking for a place to rest, soon entered the room. Da 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 da. Combs then knocked plaintiff down. Oh, there we go. So after Carter finished, he stepped back towards the wall. Combs then stepped forward and raped plaintiff while Carter and Celebrity B watched. Combs then knocked plaintiff down and attempted to force her to do that. She fought back, standing up quickly and punching out at the same time, hitting Combs in the neck. Taken aback, Combs stopped his attempt. When Combs backed away in surprise, plaintiff grabbed her clothes and shoes and ran out the bedroom, holding her dress in front of her like a towel. She ran around the residence until she found the front door and was able to leave the party. Although there were guests still at the party, no one appeared to take notice that plaintiff distressed or attempted to help her. Um, all right, so it says plaintiff attempted to retrace the route taken by the limo driver. She kept running until she reached a gas station she noticed on the way to the party. A female clerk noticed her distress and allowed her to use the phone. And so that's what we was trying to figure out, like where would there be a gas station at? Now this is more than 20 years ago. So there's no possible way. Things have changed. That gas station is probably long gone. Or, there's streets that's being rebuilt every day in neighborhoods. So things change, especially in the last 20 years. Now, she signed that the day that the amended complaint included Jay-Z, his actual name. Um, Now Fortney's, now this is David Fortney. Remember that damn, what was that? What they was saying that he was lying. Oh no, he's included in the Alabama lawsuit. So David Fortney is one of the attorneys that Jay-Z sued. And let's see. He is saying that on or around November 4th, 2024, he spoke with the plaintiff identified as Jane Doe, who at the time authorized our firm to send a demand letter to plaintiff counsel. So this is him saying that she did give him permission to, or the firm to give permission to send out those demand letters. I wish somebody would say something about John Doe, because golly, man. Um, oh, this is Vasquez. Okay. Hold it. All right, so now this is Mark Kasowitz. Mark Kasowitz is the attorney for the Busby law firm, and Jane Doe. Because remember when that we was trying to say that this was, but not Busby's attorney, Trump's attorney who entered in? Yes. Because as soon as that motion for sanctions entered the chat, Tony Busby said, "Hey, I need to get y'all on my team." And so Kasowitz actually represented Busby and Jane Doe in that matter. Now, this is what he said. This is what he said. Let me see. All right. My firm was retained and entered an appearance on behalf of the Busby parties and their Jane Doe client in the case filed on behalf of Jane Doe in the District Court of Southern District of New York against Sean Combs and others, including plaintiff Sean Carter. My firm was retained to respond to a motion for sanctions against the Busby party filed by Carter and his attorneys at Quinn Emanuel in the New York action. On or about January 22nd, 2025, my firm filed an opposition to the motion for sanctions, which I believe was meritless and, well, meritorious, and would almost certainly have been successful if the motion for sanctions had been fully litigated. On or about February 1st, I was contacted via email by John Quinn, a partner and founder of Quinn Emanuel, and his partner Alex Spiro, Carter's lead attorney in the New York action, to discuss a possible global resolution of the dispute involving Carter, Jane Doe, and the Busby parties. Thereafter, I engaged in discussions with Spiro in early February 2025. See, Spiro ain't gonna tell y'all this. The substance of our discussion include a mutual recognition that a continued public dispute was damaging for all parties, including Carter, the Busby parties, and Jane Doe, and that it would be best for all concerned to stand down and cease further litigation. So it's like Kasowitz came in as a mediator, and they all agreed that none of this was good for any of them, and the best thing for them to do is to cease further litigation. Now, this is a conversation that he had directly with Alex. Throughout my discussions with Spiro, I made it clear that both Jane Doe and the Busby parties stood by the substance of their claims against Carter, but for the reasons set forth in her February 27, 2025 declaration submitted to the court, which had nothing to do with the substance of her claims, she would consider dropping those claims, which, as set forth below, she later agreed to do so. There y'all have it. So we have another attorney that has claimed, that has came to tell y'all that this is not in regards to the substance of her claims. She stands by what she said. What happened, happened. So this case was not dismissed because she lied. Y'all have to get that out your head now. Mr. Spiro and I eventually reached an understanding that the parties would agree to a walk away whereby they would drop all of their disputes against each other and disengage from the litigation in the interest of global peace. We negotiated and agreed to a phased withdrawal of the New York action, and our agreement is reflected in an email exchange dated February 4th, 2025. And we're going to look at that copy in just a second. An email exchange with Mr. Spiro is attached here too. Spiro ain't gonna tell y'all this because he wants y'all to run with the narrative that Jane Doe is lying. As long as he has the public opinion and the public, you know, sway towards Jane Doe is lying, he's gonna keep up these antics. That's what y'all, he playing y'all. He playing on y'all intelligence and y'all letting him do it freely. It clearly states why this case was dismissed, but Spiro ain't gonna come and tell y'all that he negotiated with them. Something had to be done. I knew it wasn't a monetary settlement, but I knew they came to an agreement on something. And here we are. But Spiro ain't gonna tell y'all this. Yes. Uh-huh. What Cece said. They're going to keep on, and any proof that she had of her claim is going to come out. It is that they're going to keep poking the freaking nest until all the bees come out. The bees, the wasp, whatever. And he should have left well enough alone. But this is what happens. Now all your dirty everything is eventually going to come out as it is right now. Had this not happened, would have never known. Now I told y'all the difference between voluntary dismissal and involuntary dismissal. So we know that she did it on her own. But they came to some type of agreement. We just didn't know because it said in her dismissal that she sat down with each defendant in their counsel. But now this makes sense. So the email, the agreement, one, the withdrawal of the motion. Two, then 10. Do y'all see this? So motion for sanctions. 10 days after that, we're going to dismiss the case with prejudice. And then we all going to agree that Mr. Carter, me, myself, Alex Spiro, and the rest of Quinn Emanuel will not authorize, employ, or otherwise engage investigators or anyone else to harass or otherwise interact with my client, his law firm, or his presence and former clients, employees, or family. So I, Alex Spiro, and my firm will not mess with Tony Busby. We're not going to harass them. We're not going to interact with them. We're not going to interact with his law firm. We're not going to mess with their clients, former clients, employees, former employees, and any family members. Jane Doe follows under the former client. I'm so glad for this email chain. That's why I save all my emails. Because as soon as you be like, I didn't do this, no, I got an email that says otherwise. In accordance with our agreement, Quinn Emanuel and Carter withdrew their motion for sanctions in the New York action on or about February 4th, 2025. And further performance of our agreement and in reliance of the understanding that all parties' disputes were all to be gradually withdrawn, the Busby parties and the Jane Doe dismissed their New York action with prejudice on or about February 14th, 2025. I was surprised and disturbed. Now, this is Katzowitz saying this. I was surprised and disturbed to subsequently learn that Carter and Quinn Emanuel almost immediately sought to use negotiation dismissal of the New York action as evidence against the Busby parties in the California action, and that investigators made in-person contact with Jane Doe within a week of dismissal, notwithstanding the explicit agreement with Mr. Spiro and Carter that no such contact was to be made. The exclamatory conduct is completely contrary to the understanding that led to the dismissal of the New York action, which was premised on a mutual cessation of hostilities. Katzowitz said, "Don't play. Look at this." From Spiro. to Kasowitz. His response said okay. So you confirmed. I'm going to blow this up. Hold up. Let me blow this up. At 10:11 a.m., Alex responded to Kasowitz's email saying okay. This is what Kasowitz sent at 10:25 on February 4th. Wait. Hold up. Something ain't right. Tuesday, 10:11 a.m. and then 10:25 on it. Where's the rest of it? It gotta be some more. Wait, hold up. Well, let me read this because this is throwing me off. Spiro, here is our proposal. You and your clients, Jay-Z and Rock Nation, will withdraw the Rule 11 motion. 10 days later, plaintiff will withdraw the complaint with prejudice. Number 3, you and your clients and their agents will not authorize, employ, or otherwise engage investigators or anyone else to harass or otherwise interact with my client, his law firm, or his present and former clients, employees, and families. Neither you nor your client is admitting that you have done or known about it, just a commitment that you won't. Spiro said, okay. He said, okay. So you agreed to this. This is what you agreed to. Right here. Somebody tell Alex Spiro what he doing. Why are they harassing? Oh my gosh, I hope somebody filed a lawsuit against them. Now I'm thinking about the Texas cases, the Louisiana cases. It's all Spiro. It's all Quinn Emanuel. They send out these investigators to harass people. Y'all got I keep telling y'all, everybody, Jane Doe, I feel bad for her, but she's not the only victim in this. Do y'all not feel bad for Geraldo Garcia? Do y'all not feel bad for Jose Maldonado? Do y'all not feel bad for the ex-model that was sexually assaulted by Leon Black? And God forbid there's more people. These investigators have harassed plaintiffs, attorneys, and their families. And people are still stuck on Jane Doe lying. And y'all forget fuck all the other cases. But Jane Doe is lying. Fuck all the other cases. F all the other people that have been harassed for years by these investigators, but y'all are still stuck on Jane Doe is lying. What is wrong with you people? And that is a genuine question. If Jane Doe lying, that means Jose Maldonado is lying. That means that the ex-model is lying. That means Geraldo Garcia is lying. That means everybody's lying about the encounter, the experience that they encounter with private investigators just running up to their doors. Private investigators running up in stores, stalking their family, trying to get them to sign affidavits or learn their whereabouts with these people. It does not matter. Y'all's telling me Ramir and his godmother is lying. 4 o'clock in the morning, people driving on their grass trying to get in their homes. They have been intimidated. Judges, their own attorney working against them. But yet, everybody is not seeing the pattern because all y'all can think about is what. See, I'ma say this, and I'm an hour and 49 in. If I don't get paid for this video, oh well. But Quinny Manuel and Alex Spiro is mind fucking y'all. I'm just gonna be honest with you. That man does not, he tells half truths. He probably don't even tell the truth, period. He tells y'all what y'all want to hear. Spyro would have never came out. I don't even see people reporting this part. I haven't gone on because I've been working all day. But I haven't seen anybody that says, damn, Spyro, this is the real reason why Jane Doe dismissed her case. Y'all had an agreement that you agreed to. You said okay to. But Spyro ain't gonna tell y'all that. And people still gonna be, oh, Jane Doe, she dismissed her case because she was lying. Epstein, the judge in the California case, that says even though she dismissed her case, that does not mean that her allegations are false. Here we have a declaration from an attorney who represented Jane Doe and Tony Busby that states they had an agreement. The true reason why they dismissed the case was because she was tired of getting harassed and intimidated by Jay-Z and his freaking attorneys. So Kasowitz said, okay, let's come to an agreement. Y'all drop the motion for sanctions. We'll go ahead and we'll drop the case against Diddy and Jay-Z with prejudice. And y'all just leave her the fuck alone. Leave Tony Busby alone. Leave his clients alone. Leave his former clients alone. Leave his family. Leave his employees and everybody else alone. I'm really curious as to what everybody is going to say about this, because here it is. This is it right here. This is the reason. I told y'all eventually it was going to come out. I didn't think this way, but eventually it was going to come out. Look, y'all boys said, okay, he agreed to this. This is an agreement. And he broke that agreement. He breached this contract. He breached this agreement. This is opened for a lawsuit. And I pray that Jane Doe, and she probably doesn't want to go through this. And that's the sad part. They have harassed and intimidated this lady to where she probably doesn't even want to go against them. And that is fine. That is totally fine. But guess what? I bet you Busby ain't gonna let this motherfucker go. He about to sue Quinny Manuel. He about to sue Jay-Z. Well, actually, I mean, he kind of already does have a lawsuit against them in Texas. I want to see how that plays out. I do. I do. But here's y'all answer. So can't nobody say that she dismissed her case with prejudice because she was lying. Get that out of your heads, because it's right here in black and white. And Alex Spiro knows the truth. Y'all have to stop getting mind fucked and actually think for yourselves for once. The last one, this is Camille Vasquez, once again, Johnny Depp's attorney. She's amazing. In her declaration, she stated that on Tuesday, February 25th, 2025, a hearing was held before the above entitled court on the Busby Party special motion to strike the complaint filed by Sean Carter in the above caption action. At the hearing, counsel for Carter indicated to the court that his office had just that morning came into possession of new evidence material to the motion and requested a continuance of a few days to allow the evidence to be presented to the court, proposing that the motion could proceed with the hearing on the following Monday, March 3rd, 2025. Counsel for Carter also suggested that the evidence might indicate that the demand letters underlying this action were sent without authorization. Well, that's a lie, because we just read that she authorized it. David Fortney said that he spoke with her on the 4th and she gave the green light to send it on the 5th. The court proceeded with the hearing, but indicated that Carter could file an application to augment the record on the motion. 3 days later, on Friday, February 28, 2025, a meet and confer was held via Zoom between my office and counsel for Carter. During the conference, counsel for Carter proposed a schedule under which Carter would file an application to add new evidence on Tuesday, March 4th. We asked counsel for Carter to describe the new evidence that would be the subject of the application. Counsel indicated that she was unable to provide any new details about such evidence, but that she expected to have more information on the following Monday. Accordingly, the meet and confer was moved to Monday at 10:30 to allow counsel for Carter time to gather information about the pro-offered new evidence. On the morning of March 3rd, counsel for Carter advised via email that she needed to postpone to meet and confer to the following day. To date, 6 days after Carter's counsel represented that it was in possession of new evidence that would materially change the court analysis of the motion, no further description of the new evidence has been provided. In intervening time, the Busby parties have been provided with a declaration from their client, Jane Doe, in the underlying case that was filed against Carter in New York, which responds to the pro-offered new evidence and is being submitted to the court currently here within. And so that brings me to the next video, which is the second declaration of Jane Doe. I know that was a lot. We are about 2 hours in, but this needed to be done. This needed to be said. This needed to be addressed. In this California case, Jay-Z has stated that he has new evidence. At the February 25th hearing, his attorney stated that they were in the works of getting new evidence. They were banking on Jane Doe signing that affidavit, but it went left. So they had to find an alternative. The alternative was for Charlotte Henderson, James Butler, and Ian Pillinger to file their declarations. Pillinger's purpose of his declaration was to discredit Jane Doe by telling us, the public, because they know that it's people like me on here reading these, to present to y'all an image that Jane Doe has mental issues, that she's a criminal. So don't believe her. She's not worthy of being represented. She's not worthy of having a case like this. She's not worthy of being reliable or believable because she has a past, because she has mental issues. I want y'all to think about anybody out there who has a background. And if you are injured, or if you are a victim of SA and you go into a law firm and you tell your story, how would you feel if they said, okay, hold on, let me run a background check on you right quick, and they see you got criminal history, you got mental issues, the whole 9 yards, and they turn you away? How would you feel? That shouldn't even matter. That because this happened to you, that does not discredit your story. So that was the purpose of Ian Pillinger filing his declaration. The purpose of Charlotte filing her declaration was because they couldn't even get Jane Doe to sign. They thought that she was going to be so out of her mind, intimidated, scared, that they was going to punk her into signing an affidavit. That is what they were banking on. That was their new evidence. So now that she didn't sign an affidavit or a declaration, what's the next best thing? to get her on tape. Oh, we have an audio. Y'all only played a clip. Where's the whole audio? Why not release the whole thing? Just like we was able to go on NBC and listen from the interview from beginning to ending. How come y'all can't put out y'all little private investigators little audio clip or whatever she provided y'all? Make that make sense. So because y'all couldn't get an affidavit, the next best thing y'all thought was an audio clip that hasn't been authenticated, that hasn't gone through US Legal or any other company that transcribes and submits a certification to the court to ensure that everything in that recording, in that audio, in that phone call, in that video was true and correct. Y'all decided to just go and submit it to ABC. Where's the full clip? The way that technology is, you can manipulate, you can alter things. There are so many lawsuits out there about people altering things using AI. Where's the whole clip? They don't have a leg to stand on. They don't have a leg to. Jay-Z has no evidence. He thought he ate with this one and he did not. They tried to use Jane Doe's dismissal as evidence, saying, oh, yeah, she dismissed because she was lying. Whole time, y'all had a whole agreement because she was tired of being intimidated and harassed. So they said, y'all drop the motion for sanctions. We'll drop the suit with prejudice. And y'all agree never to fuck with them again. Spiro is dirty. We've been on here for 2 hours and I have gone through declarations submitted by Kasowitz who stated why they dismissed. I have read the opposition that was drafted by Shepard Merlin, who has broken down this case, who have cited other cases to tell y'all that those declarations from those two investigators are inadmissible because it is hearsay. Jay-Z doesn't have no new evidence. The judge has already told him, I can't reiterate this enough. The judge has already told him, don't bring me hearsay. That is why they were sitting there going back and forth about Sweetwater. It is a reason why they referenced that case in there. Do not bring me hearsay. Your extortion claim is already out the window. The demand letters were authorized. David Fortney stated he contacted Jane Doe on November 4th. She said, okay. They were authorized. She submitted 2 declarations, November 18th and December 8th. What more? Like, I'm not getting it. Jay-Z I don't know. I don't get it. Somebody who is innocent won't go through these extreme measures. And it's not just in this particular case. There are other cases out there that don't even involve sexual assault that he is going to the extreme. Yes, it is embarrassing. And let me get to these comments. I'm sorry, y'all. I be going in because that's crazy. um Black Gold said Jay-Z and Spiro are dirty. Their words holds no weight, just dirty. She said the investigators were told to say they didn't work for Jay-Z or his attorneys, but how did they expect their hearsay state? That That's going to be the funny part. I cannot wait till March 26th. Oh my God, this is when they go back for this hearing. I want to be a fly on the wall. I don't even know what day that is, but I will buy a plane ticket just to go see it in the courtroom because I really want to know what the judge says on this one because this is crazy. I feel sorry for everyone who has ever crossed Jay-Z path. I do too. I do too. Bullies, I do feel bad for Quinn Emanuel's victims, goons. They are goons. He makes them fear for their lives if they attempt to stand up to him. Yep, that's exactly what he does. My spirit told me from day one that Spiro ain't white. He looks soulless. Girl, my spirit told me from day one when Jay-Z was named. Like I said, I'm a plaintiff paralegal, so I'm always going to side with the plaintiffs. The plaintiffs in these cases, and I do have to use discretion, and I understand both sides. I really do, and I know that what the process is. But the fact of the matter is, you can tell when somebody is full of shit. When Diddy did that to Cassie and they settled, like, it wasn't even 24 hours after she filed that lawsuit that he settled with her. But there's always a disclaimer that because somebody settled, it's not an admission of guilt. In all actuality, it is. Because if I said I'm not going to do this, I am going to fight tooth and nail. I'm going to go through litigation. But that's just litigation. I'm not going to go through all these antics. I'm not going to hire private investigators to go out and harass people and stalk people. That's just going overboard with it. But the fact of the matter is, this was an agreed dismissal with stipulations that they failed to follow. You think that that's not going to be consequences? And the fact of the matter is, the judge is going to read this declaration. I am here for it. I am here for it. This about to bust hell wide open. This is not a good day for Jay and Spiro. Bye bye, guys. They're about to go all the way down. Satisfying. It is. Can you tag ABC, NBC Today? Easy. We need to be clear. We need to clear Busby's names. If you go Busby right now, it's all on the News Jane Doe hotline. And that's what you know what? I think I might do that. I just might do that because it really pisses me off that they're going to pick the bad press and not show the other. They didn't even bother to show the email? I think I might clip that up. I'm going to clip the email up and say the real reason why Jane Doe dismissed her case. Alex Spiro and Kasowitz came to a agreement, y'all. Did y'all know that? Yeah, I'm gonna type that up. It is embarrassing for them. It is. This is way past excessive. It is, and it needs to stop. It needs to stop ASAP. Sloan Bella said Jay-Z would fall before did he. If you don't know who that was, that's the one who predicted these fall like 6 months before he fell. Oh, I have no idea who that is. I need to Google that. I pray for victims, especially Jane Doe. I hope and pray that she stays strong. Yes, and that's that. And I guess I'm gonna end that on this note. Continue to pray for all of these victims. Now, there are going to be bad seeds in the bunch, and eventually, excuse me, it's going to come out that is false. But y'all don't understand the process that majority of personal injury firms go through. We do, when it comes to these type of cases, there you have to really vet because these are strong allegations that you are putting against somebody, that you're putting on somebody. So we're not going to treat this, and always told y'all this, we don't treat these cases like regular slip and fall cases or car wreck cases or trucking accidents. We don't treat them like this. These are totally cases because the allegations can be damning to the receiving party, to the party that you're going after. So I know what the process is. I've been knew what the process is. This is not something that they be like, oh, you was, sexually assaulted by this person. Okay, yeah, we'll take your case and bam. It is a process that you have to get to that point. You do have to go through. Once again, it starts off as a lead, a lead. And Tony Busby said that way when he did what everybody called him, the 1-800 lawyer. Y'all don't realize that if you're scrolling on social media, we have to advertise. I don't sit here every day and call people and be like, was you in a wreck? Was you in a wreck? Did you slip and fall in Kroger? Da, da, da. Hey, y'all. No, before I, y'all. So yesterday, I got to call this lady back. So the attorney go tag me and another paralegal that he has on his team and say, hey, it was a lead that came in. Y'all, somebody said they got hit by somebody riding the little motor carts, the motor wheelchairs at Kroger, y'all. I'm sorry, I had to get that out, y'all. I pray to God that person ain't listening to me right now in this live. If you are, I'm gonna call you, I promise. But y'all, I just had to get that out because I was like, wait, what? But anywho's, y'all don't understand the type of leads that we have coming through. So just like that one right there, we have some crazy people that come in and just say any and everything. And I mean, we do got to respond and be like, hey, we can't take your case, da 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 da. You know what I'm saying? But if it's real serious allegations, she's going to go through the how can I say this? The referral firm. That's what I'm gonna call it. Ava Law Group is like the referral firm. The referral firm be like, okay, I'm going to connect you with this firm, which was the Busby Law Firm. The Busby Law Firm had at the time just that case, and he, did it what he needed to do, and he's like, okay, we're gonna send out the man letters, and if he doesn't respond, then the next step will be litigation, in which the Curis Law Firm came into play. See, people keep leaving out Curis Law. Antigone Curis, she is the local counsel in New York, in the Southern District of New York. She is the one who is admitted. So even if Busby is out the picture, Ava Law Group and the Curis Law Firm still holding these down. So the cases are not just going anywhere. They're not just going to, fall apart or get dismissed. There's already counsel on there. That's what I be trying to shit. Curtis Law is a whole personal injury firm in the Southern District, well, that handle cases in the Southern District of New York. None of the cases that Tony Busby decided to file, sign a pleading on, those cases are not going to be dismissed, y'all. Busby doesn't even have a login to the Southern District of New York to even file a lawsuit, to let alone any other pleading. He has to submit that to the Curis Law Firm, and he say, hey, can y'all file this for me? Now, yeah, he signed the document, but it was filed under the Curis Law Firm. And that's what he's going to argue when he has his special hearing with the grievance committee. But other than that, when we're dealing with these leads, they're vetted. This is not something that us PI firms, just go out and look for random people. You may be scrolling on Facebook, you may be scrolling on any social media platform, and you may see an ad that say, have you been hurt in an accident? Or have you, used baby powder in the past? Whatever the lead is. And that's how we get our leads. But I say all of this to say, Jane Doe was never lying. Jane Doe is standing 10 toes down with her allegations. She's not switching it up. Jay-Z, Quinn Emanuel, Alex Spiro are doing everything in their power to discredit Jane Doe and the Busby Law Firm. I mean, everything. They're pulling all the tricks out of the bag, and it is causing them to sink. Sit back, observe, listen, understand the litigation process and how it works. Those declarations by the private investigators are hearsay. They're not admissible in court. What they did should not have been done. They were banking on Jane Doe submitting that affidavit, and that fell through. Then they tried to release audio that has not been authenticated, has not been transcribed, has not been certified, but trying to make you think that Jane Doe recanted her story. She has submitted a total of 4 declarations telling her story, and nobody is listening. Everybody still has in their head, even after this, I showed y'all a whole email that Alex Spiro agreed to as the reason why that case was dismissed. And people are still going to run with the fact that she dismissed it because she was lying. That speaks a little about your character, and it speaks to you about your comprehension skills. But thank y'all for tapping in. Thank y'all for those who sent super chats, is very much appreciated. I gotta take a break because this is a lot. Definitely tap into the second declaration video. I know it's stream. I think I premiered it at 6 p.m. We're well over that time, but I talk about the second declaration of Jane Doe, as well as what objections the Shepherd Mullen Richard Hampton law firm put in regards to Charlotte Henderson's declaration, because at the end of the day, those are hearsay. Those are hearsay. Those declarations by those 3 individuals, Charlotte Henderson, James Butler, and Ian Pillinger, those should be stricken from the docket. Hearsay. Well, at least 2, James and Charlotte. But as far as Ian Pillinger, what was the purpose of your declaration other to bring Jane Doe down and make her look bad? That's it. But yeah, thank y'all for tapping in. Y'all are awesome. I'm about to take a break and probably watch other YouTube and see what I can get into. But thank y'all for tapping in to the replay game. What's up? Y'all leave a comment below. Don't forget to like, share, and subscribe to the replay game. Y'all can send I think purchase thanks, super thanks, or something like that. And I do have merch available, but any support by y'all just watching the video alone is enough support for me. Thank y'all for tapping in. Until then, I'll catch y'all in the next one. Be blessed, y'all. Bye.